Okay, this is what I'm going to do. I'm going to start with some probate process. I'm going to, in that, talk about why we need an attorney and when we need an attorney. I'm going to talk about last wills and testaments and some of these advanced directives that we've talked about. I'm going to pull in a trust part of the discussion, and then I'm going to rotate around to some common problems in estate planning and caring for senior parents, and then I'm going to wind up talking about long-term care. Is that okay? All right, we got a plan now. Okay, what is the probate process? Does anybody know? She says you just want to avoid it, okay? If you die, you might not be able to avoid it. You know, there are ways to avoid parts of probate, though.
Passing the estate to the next generation, or to the
Passing the estate to the next generation. Exactly right. Thank you. And we got a talker here, too, by the way. Thank you. So, all right, during our lifetime, we transfer assets into our name, right? If we want to sell those assets, we just sign a document and transfer it out of our name, right? Easy enough. When we die, we still have a lot of assets in our name, correct? But we can't sign that piece of paper transferring them anymore, right? We need someone with the authority to do that. Who's that person? Executor of the estate. Okay, the executor of the estate is exactly right. The executor of the estate acting under the authority of the probate court, the probate court judge, right? Now, the probate court judge, he wears a black robe. He spent his entire life earning the right to wear that black robe. He's elected by all of us. Therefore, he's going to make sure that that process happens properly. And so there is a process for probate established under the Ohio Revised Code. And you know what? We have a lot of people who die in Ohio every year. But the probate court judge does not change the rules every time a new person dies. So sometimes clients will say to me, Jonathan, this rule doesn't make any sense for my estate. And I'll say, that's exactly right. But do you know what? The probate court follows the rules every time. That process is the probate court process. Does that make sense? Right, exactly right. So what does the judge want to know through the probate court process? The judge wants to know who is listed in the last will and testament. The judge wants to know who are the natural objects of our bounty, our children usually. The judge wants to know what assets he's going to be dealing with, right? And so we have to give him that information step by step as we go. The judge wants to make sure that we've properly disposed of the body. That's a Department of Health requirement. The judge wants to know what our debts are. And then the judge gives the executor an appointment to carry out the requirements of the last will and testament, to settle the debts, to distribute the assets, and then to account to the judge for what they've done. That is the probate court process. Now, it's step by step, right? You can't do all that at once. And you have to give people the opportunity to speak, right? If they want to challenge what's going on, or if they have any questions, or if they are owed money. And so it does take a little bit of time, right? It's not a horrible process. There is some expense involved with it, but when you pass away, whether it's through a trust or through a last will and testament or otherwise, there's always an expense, okay? It's not to be afraid of. It is a tool, okay? But like any tool, I cannot build a house entirely with a hammer, right? Okay? So some people will say to me, which is better, a trust or a last will and testament? I mean, if I'm hammering, if I have a nail, I'm not going to try to hammer it in with a screwdriver, usually, right? And if I have a screw, I'm not going to try to drive it with a hammer, again, usually, right? It's the right tool for the right job. Does that make sense? Okay. Why do you need a lawyer? Well, you know, being a lawyer, I mean, I'm real kind of touchy about this because, you know, I don't want to, you know, sell myself. I want to assist people, if that makes any sense. But years of doing this tells me that you certainly need to have a lawyer review what you've done, okay? Because you can make mistakes. I had a client many years ago who hated lawyers. Oh my goodness, she hated lawyers, okay? And so she did her own last will and testament. You know what? I was able to transfer her assets utilizing that last will and testament that her sons brought to me. But she did not waive bond under that last will and testament, okay? So she did save a few $100s by not bringing it to a lawyer. But it cost her $21,000 to purchase the bond to put on the executor to advance the estate. So, I mean, you can make mistakes without even knowing that you're making mistakes, okay? And there's something about wills, too, that you have to be aware of. Wills are governed not by intent. They are governed by words, okay? Wills are governed by words, not by intent. Interestingly, trusts are governed by intent and not by words, okay? In fact, I don't have to have a writing at all to create a trust. So I say that wills are kind of governed by voodoo. You got to say exactly the right thing. You got to follow exactly the right procedure, okay, in order to get these things through. I can go in front of a judge and say, Judge, I know what the will says, but the testator's intent, and I can prove the testator's intent was to do something else. And the judge will pull down his glasses and look at me and say, Mr. Sams, I do not care what the testator's intent was. The last will and testament says this, and this is what we're going to do. Conversely, by the way, I can go in front of a judge, and I can say, with a trust, and I can say, Judge, the words of the trust say this. And the judge will pull down his glasses and say, Mr. Sams, I do not care what the words say. I only care what the intent of the trustor was, okay? Now, of course, the words hopefully will express the intent, right? So we want both to be together, right? So, any questions on the probate court process? Yeah?
What kind of time are we looking at in the state of Ohio for an uncontested probate?
Oh, give it.
Well, yes.
Give it 9 months, but it can be more and it can be less. And you know what really slows these things down? 2 factors that will really slow it down. Number 1, the house, right? If we're selling the house out of the estate, that'll slow it down. Number 2, contests. If somebody contests it, it'll challenge it. Oh, there's something else that can slow us down. Hoarders. Oh my goodness, hoarders will slow us down because we'll walk into a house, right? And there'll be newspapers stacked from floor to ceiling where you have corridors where you can walk through these things. And do you know what? If you're a hoarder, then that stock certificate, where's it going to be? Right there. But I'll walk through the front door here. We're going through newspapers, right? That'll slow you down too. Yes, sir.
Is there any way of avoiding probate?
Okay. I'm going to hit that, but I'm actually going to use that as a topic here in a second, okay?
If you want to change executors, what do you need paper-wise? Change the whole will?
You amend the will. Now, it used to be that we would make codicils. The question is, for the cameras and otherwise, if you want to amend the estate, what do you do, right? Especially with regard to executors in this instance. It used to be we would issue codicils. You and me, we both have some gray hair, right? We remember a day when we would pull out carbon paper, right? Our secretaries would be, oh man, they could type in those days. Right? That's what they would do. Now we got computers. The problem I have with codicils, it's like layering a cake. Every time you put a codicil on, then you get a little different interpretation of that original, and it's just as easy to issue a new will now, okay? So even if I'm just changing executors these days, I draft a whole new will, so there's no question. I don't have to reinterpret what's going on. Yes, ma'am.
This is just a comment. With the will became in trouble to get it back out.
All right, so here's the issue. The question is, should you file a last will and testament with probate? under almost no, it caused this family some problems subsequently. Under almost no circumstance do I ever file the will ahead of time with probate because I might change the thing, right? So very rarely do I do that. The only time, now you can do that. You can file a will with the probate court ahead of time. The only time I ever do that is when I have someone who's distributing the assets and they're concerned that there's going to be a will challenge and that their competency might be challenged. Okay? Because one of the children doesn't like how the assets are going to be distributed, right? But mom or dad, they know what they want. Okay, that's fine. Let's go down and let's talk to the judge ahead of time. Because it's very hard for son or daughter to say, she doesn't know what she's doing. And mom's over there saying, Judge, I know what I'm doing, okay? Then we can go ahead and we can have it admitted. Yes, sir.
That raises the other question, where should the will be kept?
Where should the will be kept? There's all sorts of different philosophies, and I will demonstrate that there are different philosophies. Taft, Stettinius, and Hollister, where I am now a partner, takes those last will and testaments, puts them in an envelope, folds them up, and barcodes them, and they keep them, okay? That is a good philosophy. You know where it is. It feels kind of official. There's some really great things about that too, okay? The way I've traditionally done it myself, remember I was Sam's Fisher, ran my own firm for 18 years. I kept a copy because I can always prove up a copy, right? And I sent the original home with the family, and I usually tell them to keep it in a fireproof box or safe inside their homes, right? Don't worry about it being lost or destroyed. I can take care of that, okay? I have a copy at my offices. But that way, number one, we know where the family knows where the official documents are. Whether at Taft or at my house, I always put them into a packet so that you can sit down with the family and review it very easily. They will see it, they will understand it. And keep in mind, I came out of a small firm too. That way, if I ever died, when, right? Then they wouldn't have to rely on me to pull those documents up, okay? So the law firm who drafts it can keep it as long as they have a good process, and we do at Taft, okay? Or I'm comfortable with you keeping it in a fireproof box or safe inside your home. My least favorite, though sometimes people do it, is in a safe deposit box because if it's after hours, you can't get to it, right? Okay, now there was a question. What was your question again? Oh, transferring assets. Do you have to use probate? Okay, sometimes people will convolute two issues. The conveyance of assets, and the taxation of assets, okay? Assets get taxed no matter how you convey them, okay? It's a totally different issue than the conveyance of assets. At the moment, I'm just going to talk about the conveyance of assets. Now, we talked about what is the purpose of probate court. The purpose of probate court is to transfer title of assets, right? Okay. If you have already provided for a method of conveyance of assets, then you don't need the guy in the black robe to transfer them, okay? Here are some instances without a trust where you can transfer title to assets without going through probate court. Real estate, joint with right of survivorship. Okay? If we own real estate together and I put it as joint with right of survivorship and I pass away, well, I owned 100% of that real estate and you owned 100% of that real estate. We don't have to transfer it. Okay? Transfer on death designation with real estate. I wrote a document that said, upon my death, this property transfers to whomever I've designated. Okay? All I have to do is go to the recorder's office, sign an affidavit, death certificate, and the property transfers. Okay? Beneficiary designations. So what are some places where you have beneficiary designations?
IRAs.
IRAs, you have beneficiary. Yeah, we need to talk about that too. Beneficiary designations. I got you. Life insurance, beneficiary designations. Others? Annuities? 401k, exactly right. Wherever you have a beneficiary designation, we've already provided for the method of conveyance, right? Trusts. Trusts have a trustee, right? That trust keeps going even if the original trustee and trustor pass away. It still has a successor trustee. So we don't need to have the probate court judge, right? So beneficiary designation. Yes, ma'am, you had a question.
Does a TOD for real estate supersede a will?
It does not even touch the will. So it transfers before the will ever comes into place. Okay?
What was the question, John?
The question was, does a TOD supersede a last will and testament? Okay?
What is a TOD?
Transfer on death designation. Okay? And here's the thing. If the property transfers by operation of someone's death, then that property just transfers, right? And so when the judge opens it up, so I have a TOD on 1 South Street, okay? So 1 South Street transfers on death via TOD designation. And so when the judge goes through and looks at the will, and he sees transfer 1 South Street, he'll say, okay, is 1 South Street in that probate estate? No, it's already transferred. All right, I'll read that out. Doesn't exist within the probate estate. Okay? Make sense? All right. Bank accounts. Bank accounts can be held jointly, right? Yeah. So my wife and I have joint bank accounts. When I die, it goes to her, right? Because she owns it 100% already. Okay? As do I. So, yes, there are ways to transfer assets outside of probate. Okay? I do want to segue, since I just mentioned 401ks and IRAs. The rules are broader than this, but this is a big group, and so I'm going to keep it simple. Okay? One of the things that you need to know about 401ks and IRAs are the stretch provisions within those. People hear it, they don't understand it. Okay? Now, I have a 401k, right? I receive the deferral of recognition of income tax. I receive the deferral of recognition of income tax. That makes sense to everybody? I'm not paying tax on them right now, including what it grows? Okay. Did you know that if I pass... Now, also, when I turn 70 and a half, I have to start taking required minimum distributions, okay? I pay tax on what I withdraw at ordinary income tax rates. Does that make sense? Okay. Do you know that if you pass it to your spouse, that they also receive the deferral of recognition of income taxes? You know that, right? Do you know also that if you pass it to your children, that they also receive deferral of recognition of income taxes? That's a pretty good benefit, right? Now, your children do have to start taking required minimum distributions upon your 70 and a half birthday, even if you're not alive anymore, right? But they don't have to base that upon my lifetime. They get to base the required minimum distributions upon the remainder of their lifetimes, starting at my 70 and a half birthday. That's a pretty good benefit, right? Something to be aware of when you're doing your planning, right? How long is this class, by the way?
10:15-ish.
10:15-ish? All right, good. It's 9:37, so we're cooking along pretty good. Okay. I'm going to talk a little bit about, heaven forbid, estate taxes. Okay? Before I do that, do you have questions about what we've covered so far? Yes, sir.
I didn't exactly understand what you just said about the 401k.
Yeah.
When they have
For beneficial IRAs. Okay? So if I give my children my IRA, they don't get to wait till they're 70 and a half. Okay? When I would have turned 70 and a half, they have to start. But they don't base that upon my life. So my life expectancy at age 70 and a half is like 14 years. And so you base your required minimum distributions based upon that 14-year period. Okay? If I die at 70, right? And so my kids are 40, then when I would have turned 70 and a half, they have to start taking required minimum distributions. But they get to do it over the remainder of their lifetime, 40 to 84, so they got 44 years to withdraw. Give, take. All right? Good? Okay. Any other questions on, yeah?
Multiple executors?
Multiple executors. I get this conversation. I get Mrs. Jones who comes to me and says, Jonathan, I don't want to treat one child in preference to any other child. So I want to let two of them be executors. Or, even worse, Jonathan, my children are going to fight like cats and dogs, and so I want to name them both executors. All right, let's talk about that. Two executors. Two executors have to sign everything. Two executors have to agree on what's going to be done. If they can't agree, then I got to talk to the probate court judge, right? Look, you make a last will and testament, make sure you're clear in your last will and testament. The lawyer and the judge are going to make sure that what you say in your last will and testament is going to happen, all right? The executor does have a lot of authority, but it's all confined within the terms of that document. I prefer, not that I don't write them otherwise if my client insists, I prefer one executor and then a successor executor. That's my preference, okay? There can be reasons why it makes sense to have two, okay? There can be reasons, but by and large, I prefer one, okay? If there are, well, you can have real estate located in more than one state, and you can have children located in more than one state. I could see maybe if the children, if you have property in Tennessee and you have a child in Tennessee and property in Ohio and a child in Ohio. Okay, I got it. I understand. You want this one to have the authority to operate in Tennessee and this one to operate in Ohio. I can see that. Okay. If you just insist, okay, I mean, ultimately you're the client. I'll throw up my red flags, and warn you. But if you insist, I mean, it's your last will and testament. So, all right. Yes, sir.
If you do have a situation, let's say where you have two co-executors, let's just say two brothers.
Yeah.
It is possible for one brother, if this is what they want to do, to sign away his and then you've got just one, right?
Here's the question. If you have two executors named, is it possible for one of them to decline so you only have one? Yes. In fact, that happens a lot, okay? Because the kids all say, we know why mom did that, but honestly, he's got more time or he's got more inclination. Let's let him be the executor. I know he's going to do it just fine. So at least half the time or more, one of the children decline anyway. The only time when they don't, in fact, they feel guilty sometimes when they do. We ought to decline, but mom made the last will and testament saying, wow, I don't want anybody to feel favorite. And the kids say, I really wish that Joe was doing it, but mom wanted me to be the executor, so I'll do it. And so, I mean, we're all just, I mean, it's very nice that everyone's sensitive about each other and highly inefficient. And yes, ma'am.
What is the state law for Ohio? Do they have to live in the state of Ohio?
Not if you're blood.
Pardon?
Not if you're blood. Do they have to live in the state of Ohio was the question. Blood, they don't absolutely have to.
Is there any way that the executor gets paid for doing this?
Does the executor get paid for being an executor? Yes, there's an executor fee associated, which very often they decline, but sometimes they get paid. Yes, ma'am.
Your wisdom around making it a sort of third party that's uninvolved, a financial advisor or a lawyer versus a child.
Yeah, if especially if you're expecting a dispute, then you can hire a third party to do it. If children don't live in the same state, they're far away, they're distant from the assets, they have difficulty managing the real estate, for example, then yeah, banks do a great job with that. Or there's some third party organizations that are fiduciaries. Yes, sir.
I may have the wrong word here, but is there look back in the government? I just got introduced to that term, where they come back and for a period of time.
There are all kinds of look backs. Estate taxation look backs, Medicaid planning look backs. But as far as just generally drafting a will and distributing assets, no, look backs are not applicable. Yes?
Is there anything that absolutely has to go through a will and probate versus just assigning the beneficiary?
There are usually ways, if you say, I absolutely don't want this to go through probate, that I can help you escape probate, if that's the purpose. Now, sometimes it's actually easier or more organized or resolves disputes by sending it through probate. But off the top of my head, I can't think of assets I couldn't get out of probate.
Is there any instance where, let's say you have a trust that is, you have one executor of the trust, and it might be a son, but in that family, there might be 6 or 7 other kids, let's just say. Is that trust public to all those parties, or can they keep it secret just to just to the executor? I hope I worded that correctly.
I got you.
Okay.
All right, so we have a situation where you have a trust. I haven't yet started to talk about trusts. You have a trust with multiple beneficiaries, one trustee. We're presuming that all the beneficiaries and the trustee are all siblings. Can you conceal, as a trustor, the contents of the trust from the other beneficiaries? The answer is yes, you can. You do so. Now, Ohio law requires accountings, requires distribution of the documentation, right? But you can also name a surrogate for the receipt of information, okay? And so if you wanted to, if you actually didn't want, and I do run into this, I run into it pretty frequently. So mom and dad have never told kids how much money they have. They're 40 years old, they've got $4 million in assets. They want the kids to stand on their own 2 feet. Children are young, right? They don't want the kids to know that they're entitled to $1 million, you know? Maybe later we'll let them know, right? So let's name a surrogate for the receipt of information right now, so the kids stand on their own 2 feet, okay? Later, when the kids get older, we'll start distributing information to those children. Okay? Otherwise, kids say, I'm going to slack through college, I plan to go on the Ferrari plan, and everything's going to be good, right? All right, let's talk about trusts here, okay? I'm checking my time, by the way. Okay. Trusts, we used to use a lot, and honestly, the tail drove the dog, okay? Say tail wagged the dog, right? This is the reason why. Until not too long ago, right? What we call the credit shelter amount was $600,000. Okay? $600,000. In Ohio, $332,500. Okay? In Ohio, you had up to a 7% estate tax. All kinds of taxes, right? Income taxes, capital gains taxes, gasoline taxes, luxury taxes, lots of taxes, but also a capital gains tax, estate tax. And just because you pay one tax doesn't mean you don't also pay all the others. It's like a hand of cards, right? Just because you got the king doesn't mean you don't also have the ace, right, and the 2, right? Okay, so you pay lots of taxes. Estate taxes is what your estate pays when you pass away. The state of Ohio had a 7% estate tax. Any idea as to what the federal estate tax rate was?
Add a 0.
How about that, huh? 55% for everything above $600,000. Now you get some credits back and forth, but 60% of what you got gets taxed if you have more than $600,000. And see these little hands right here? They've written great big checks for people who didn't plan, all right? Big checks. When you're writing a check that says $452,000 and you're saying to yourself, every penny avoidable, that's a bad day. All right? These hands right here. So, because we had such significant estate taxes, we did a lot of tax planning. And I'll show you kind of how that worked. And by the way, a big industry rose up around this too. Okay? An industry rose up around this. Sorry, Adam. I stepped outside of the brown box. Yeah, actually, what would happen? I mean, it's a good thing too, but in some ways, some planners would try to segue legitimacy by pulling a lawyer in to do trust planning, so that they could do financial planning as well, right? I mean, a big industry grew up around. So you had an industry that was driving. Everybody in this room was being told that they had to have a trust immediately, or else they were going to die within a week or something like that, right? And okay, trusts are a tool. Okay, they're a planning tool. This is how this used to work. So you had a husband. By the way, I hope that these are not permanent. And you had a wife, right? And let's suppose they had $1,200,000 in assets. There are two roads, only two roads, no more, no less, that assets can pass for estate taxation purposes. One is the credit shelter or the unified credit. That was at $600,000. Husband had one, wife had one. Everybody with me? So one of the ways that assets could pass for estate taxation purposes was via the unified credit. The only other road was the unlimited marital deduction. Unlimited marital deduction says you can pass anything back and forth between husband and wife during life or at death, totally gift tax free, totally estate tax free. Okay? So if husband passed all the assets to wife at death, sorry guys, if husband passed all the assets to wife at death, then those assets would go via the unlimited marital deduction. At this stage, there were 0 estate taxes. You guys with me? All right. Subsequently, when wife passed away, so after that transaction, she herself would hold $1,200,000 in assets. Subsequently, when wife passed away, she would pass them to the 2 children. Okay? This is an unlimited marital deduction. Only applies to husband and wife, right? Only one other road, right? Credit shelter amount. So, $1,200,000 in assets protected by her credit shelter would leave $600,000 to be taxed. At 55%, I'll call it 50 because it's easier for me to calculate. $300,000 in estate tax. Got it? That's why we use trusts. You'll notice we used her credit shelter amount and we totally lost his. Okay? What we would do is, I call these, by the way, I love you wills. All right? It's semi-erasable. What we would do is we would establish a trust. It's revocable, amendable, do whatever. We would put those assets into the trust or two trusts. Sometimes one trust, sometimes two, right? Depending on needs. So now there's $1.2 million. I would write a document that I write, that we write together, called a trust agreement. This trust agreement governs the trust. Okay? The trust would say, upon the death of the first spouse, sorry guys, that this trust actually divides into two trusts, an A trust and a B trust, survivor's trust, decedent's trust, or as my dad says, above ground, below ground, right? I would put half the assets into each trust. This is kind of like a magic trick, by the way, okay? I put half the assets into each trust, right? This trust is not technically a gift to the wife. It is technically a gift to the children. They just don't get them yet. Instead, the spouse gets to enjoy the benefits of this trust during lifetime. This is technically a gift to the children. If it's a gift to the children, it cannot go via the unlimited marital deduction. That only applies to spouses. So we're actually able to use his credit shelter amount right there. Subsequently, when she passes away, we're able to use her credit shelter amount here, and all the assets are distributed to the children. $1.2 million protected by his, protected by hers. That leaves zero to be taxed. That's where the magic part of the trick comes, right? And you save $300,000. Okay? That's planning. That's why we use trusts. January 1st, hold on, I'll get it. January 1st, 2013, the state of Ohio eliminated its estate tax. Ohio has no estate tax now. Concurrently, the federal government both reduced rates, but went to a $5 million credit shelter amount with complete portability between spouses, which means I can protect $10 million from estate taxes without using a trust. Got it? If you don't have more than $10 million in the state of Ohio, you don't have estate taxes. That's a better solution, right? Now the tail doesn't wag the dog. I'm making sure I'm in my brown box. Now the tail does not wag the dog. Now I can use trusts for what we really should have been using them for in the first place. Okay? So, are trusts necessary? Look, if I have young children, okay, and I need to provide for ongoing management of assets for those children, I can do that through a last will and testament and a testamentary trust, or I can do it with a revocable living trust. And that's a discussion that we will have together, okay, to make that decision. If I have disabled loved ones, okay, and I need to provide for them, then we'll talk about utilizing a trust. See, I'm talking about asset management with a purpose. If I have a second marriage, he with his children and he with his assets, she with her children, she with her assets, and they want to provide for their children separately, we will probably talk about using a trust. Okay? So there are reasons to do so. See, I mean, this is part of the planning process. Every person in here is different. Different children, different life circumstances, different assets. Okay? We need to have a discussion. I'm really not selling my services. You know, you and your attorney need to have a discussion. Okay? Apply some wisdom. Think about it. Think about your goals. where you're going, okay? Then I'll be able to tell you whether there's a need for a trust, okay? It's interesting to me because I used to do it for taxes, and this thing used to drive the market. People seem to be reinvigorated with more of a purpose-driven estate plan thought process now than they used to be, which I think is good for our society and good for our population, and frankly, good for the generations that come after us as well. Okay? All right, I've covered a lot of turf. Questions? Yes, sir.
When does a trust have to be funded?
When does a trust have to be funded? I can fund a trust anytime. For general estate planning trusts, I kind of like to do it up front generally. And the reason for that is if I don't fund it up front, then later when the person dies, then I have to take those assets through the probate process or through beneficiary designations as the case may be, and put those assets into the trust then, and then take them from the trust and make sure that we have the management. So it's kind of two settlement processes. So I do like to fund them ahead of time. Yeah?
Can you just say 50/50 and leave it at that? I mean, 50 goes to one trust, 50% goes to the other trust?
Yeah, you can do anything. I mean, whatever good planning says, then we can do. And I think that
You don't have to
varies.
say, okay, this stock goes into this trust.
Oh no. In fact, today whenever I do trusts, I don't fund like this anymore, period. Okay? I use disclaimer provisions because I don't need the A trust and B trust in most circumstances. Okay? I say, okay, we're basically just going to keep this trust, which will fund here, right? Forget about that B trust. Mostly I just keep the assets here, which means the spouse has complete control over them, right? I got to feel threatened by $10 million in assets or a fear that the law is going to change to do otherwise, okay? But I do have a disclaimer provision in there so that the surviving spouse can exercise a disclaimer and say, I'm going to disclaim assets. Any assets disclaimed will go to the B trust. If I begin to feel threatened, that was a complex and technical conversation I just had, and I expect that 90% of you I lost on that, okay? But it's a question, so I answered it, okay? So, yes, ma'am.
If a state still has a state taxes, isn't the 5 million in each state, or is each state different?
The 55% and the $5 million, it's not 55% anymore either, by the way.
I
But
know, but
that
it's
$5 million
$5
process is the federal
So you have to
credit
check
shelter
for each
amount.
state then.
But there is also separately a state estate tax, okay? And like New Jersey, you don't want to die in New Jersey, okay? It's the worst planning I can give to you is to die in New Jersey or New York, okay? Because they still have very substantial
So you need to check
estate
for
tax.
each state.
Oh, yeah. Absolutely. Yes, ma'am.
But if you live and die in this state, but your kids live in another state, will they have to pay taxes for inheritance?
If you live in the state of Ohio, right, you die in the state of Ohio, do your kids who live in a different state, do they have to pay estate taxes?
Or inheritance, whatever it is.
Thank you. Or inheritance. That's exactly what I needed to hear. That's the next phrase. Estate taxes will tax the estate, but there are states who tax the receipt of monies rather than taxing the estate itself. Most states do not do that.
Most states don't do that.
Most states do not do that. It is. There are some states in the Northeast that will tax inheritance, and I'm not sure whether Washington State does. You know, I don't know all of them off the top of my head. I dealt with Oregon recently, and they actually did an estate tax rather than an inheritance tax. So most states do the estate tax, but there are some that do the inheritance tax. Yes, sir.
Does TOD trump the estate or vice versa?
Estate is a broad term and can be applied at various levels, okay? But with regard to a last will and testament, The last will and testament will only distribute assets that are contained within the probate estate, because the judge only will use, it's a letter of instructions to the judge for distribution of the assets in the probate estate. Probate estate, okay? If you've passed it outside of the probate estate, through TOD, for example, then it never got to the probate estate, okay? And so that will, it's not a matter of trumping, it just never got to a place where it was distributed, okay? Yes?
Once the assets of a trust have been distributed to all the receivers,
Beneficiaries?
beneficiaries, okay, how long would you be required as an executor to hold on to the records of the trust before you can actually?
Yeah, how long do you keep records in a trust estate or a probate estate as the executor or the trustee? How long should you keep those? My firm, I've always had a policy of maintaining records 7 years after the date of the last estate tax return, if it's uncontested, because you have 7 years, you have 3 years, but really they can extend that to 7 years for lookbacks and taking a look at that. Yes, sir.
Assets transferred by TOD or beneficiary is subject to gift taxes at all.
Are assets that are transferred via TOD or beneficiary subject to gift taxes? A moment ago, I used the phrase unified credit, right? Unified credit. That means that's a credit that's offset against both the estate tax and the gift tax system, okay? Transfers actually made during life are subject to gift taxes, but you have a credit that will protect you against that. You have, oh gosh, I don't want to get too technical. You have a carryover basis, so if you bought a property for $50,000 and it's worth $150,000 and you gift it, then the person who receives the property still has a $50,000 basis in that property, which means if they sell it for $150,000, they'll have a $100,000 gain, and you'll pay capital gains taxes on that. If you die owning that property, including through beneficiary designation or through TOD, you get a step up in basis, which means that your basis becomes $150,000 and there is no capital gain on that property once it's sold. Same thing. POD, TOD, you think about it, just make it easy. It's a little different, but it's the same thing. All right? All right, I'm gonna switch gears, okay? Because this in the last 10 minutes, this is kind of and I'll be here all week, folks. So, I mean, you got questions, talk to me, all right? But I do want to talk about these topics before I get out of here. All right? My family's been in long-term care for a long time, okay? People worry about long-term care, and they worry about Alzheimer's, okay? Or families have family members who have a disability that comes to them. Okay, I'm going to tell you a little story here. I had a client who came to me, a beloved client, okay? Not a believer. And she said, Jonathan, I have Alzheimer's, as you know, and have been struggling with that. She's relatively young. I want you to advise me as to Oregon's right to die laws. All right? Beloved client, represented for many years. Okay, so I did what she asked. She and her husband were both there. And I came back and gave the information that she needed. But I told her, look, just because you have a reduction in capacity does not mean that there is a reduction in your humanity, right? Because the value of our life is worth so much more than just our ability to articulate, right? There's our ability to love and take care of each other and to be loved too. Right? So if you come to a point in your life where you have a disability, guess what? It's not a reduction in your humanity. Or if your parents have a reduction in their capacity, it's not a reduction in their humanity. People don't know what to do. I'll tell you what to do. Enjoy those days. Okay? Take those days and let them be some of the best. Right? If that person loved chocolate with complete capacity, guess what? They're still going to love chocolate. If they loved music, they're still going to love music. In fact, you'll see Alzheimer's patients sing with you, right? If they love to listen to stories, they'll still love to listen to stories. If they loved touch, they'll still love touch. Okay? A reduction in capacity is not a reduction in your humanity. All right. When thinking about long-term care facilities, right, don't wait until the last possible moment to go and look. Do that ahead of time. Go together. Find a place that you like, that you feel you have good communication with. Okay? A lot of times the good places will have wait lists. Get on the wait list. Okay? Just because you're on the wait list doesn't mean you have to take a bed when one becomes available. All right? If you think, say you have $300,000-$400,000 and yet you think that Medicaid may become something that's necessary in the future, that's the state program that helps pay for long-term care, Medicaid, then make sure the facility that you are taking mom or dad to, or that you are looking at yourself, make sure that it's Medicaid qualified. They have to give the same care to the Medicaid beds that they give to any other bed, okay? But this is how the business plan of these places work, right? During the Medicaid portion of the stay, the organization loses money, right? During the private pay portion, the organization makes money. All in all, you'll find a lot of these places are not for profit, or if they are profit, they run very similarly, right? All in all, it's about a wash, okay? They use this portion of the private pay to pay for the Medicaid portion, which elevates the care given in the facility overall. Now, if you go to a private pay without the Medicaid portion, right, when that money goes away, they're not going to be able to keep the person, right? There's no more source of revenue. So the patient has to go, which means that you then go to a facility that is Medicaid qualified, but is not supported by the private pay portion also, which means the overall care, not necessarily the care, but the overall quality of the facility, the amenities to the facility, maybe some of the staffing, is less because they simply can't afford to do what this organization did, because this organization is based upon a business plan based upon both, right? Does that make sense to you guys? Memory care, okay? If you think memory care is going to be necessary, find a facility that has memory care, okay? Those facilities definitely have wait lists, sometimes years. Got it? Powers of attorneys, okay? Those grant to someone the authority to make decisions for you during your lifetime, very often if you can't do it yourself, okay? They fall into financial or property powers of attorney and healthcare powers of attorney. Healthcare powers of attorney, which are up here, healthcare powers of attorney give the power holder the ability to make little healthcare decisions all the way up to life and death healthcare decisions, including potentially the authority to withdraw nutrition and hydration, that means feeding tubes, if a standard is met. Here's the standard. 2 physicians, one of whom must be your attending physician, must both agree to a reasonable degree of medical certainty, that's a medical term of art, that you're in a permanently unconscious state or terminal condition and that you're never coming out of it, okay? Permanent Permanently unconscious state means you're unaware of yourself or your surrounding. Terminal condition means that you're likely to die within a relatively short period of time. In other words, they're not going to bring you back to life just to let you die again. Okay? So that's what a healthcare power of attorney is. Your living will is your advance directive. That's your letter to your doctor. Says, Doc, if I'm in a permanently unconscious state or terminal condition, don't take heroic measures to keep me artificially alive. And by the way, withdraw nutrition and hydration if I'm in such a state. Okay, that's an option. Now, within my powers of attorney, I like to give the final, this is different from what Ohio law says. Ohio law says that the living will trumps the power of attorney for health care. That really gives me the heebie-jeebies. That's a technical term. Gives me the, yeah, he's asked me to explain heebie-jeebies. Okay, I'm a little uncomfortable signing at my conference room table a living will that says pull the plug without really knowing what the circumstances are, right? Some people just say, I don't want to put that burden on my family, and so just do it. So I put a clause in my durable power of attorney for health care that says, give the final say to my healthcare power of attorney to give the final word on it. There can be a lot of reasons for that. Maybe you need family to come in. Maybe it's your own emotional state that says, look, this is exactly the kind of thing that he or she would pull through. I want to give it another few days. Okay? They're important documents. Doctors do rely on them. Whenever you come to us, and I would really recommend this no matter what attorney you use, I like to take my business card. I advise my client to take my business card, put it back to back with their primary care physician's business card after these documents are made, right? On primary care physician's business card, write primary care physician. Get the two laminated together, put them in your wallet, so if you're traveling in California, they can get to your lawyer with your documents, or more importantly, flip it over, they can get to your physician with your medical records, right? By the way, if you have a primary care, number one, you should have a primary care physician. Number two, if you go and see a specialist or do anything, send the primary care physician the medical records, because everybody needs a quarterback. You need somebody to be coordinating the information and understand what's going on comprehensively. Okay? Oh, last thing. I'm 30 seconds past time right at this second, okay? Last thing. Also very important. Every patient needs an advocate, whether it's in the hospital or in the nursing home. The doctors know the medicine, right? And so people, they come in with the white coats, people are a little intimidated by the doctors, but the doctors are actually relying on you too, okay? The doctors know the medicine. You know the patient, okay? Advocate for the patient with the doctor. The doctors will not resent you for that. They will appreciate that you are helping them apply what they know to the situation at hand. Okay, there may be an allergy that they're unaware of. There may be a personality issue that they are unaware of. There may be a quality of life morality that you know that they don't know, and that helps them decide what they are going to prescribe for this patient. Just like me. I know the law, right? But I don't know you, and I don't know the circumstances. Help me understand that. Help your doctor understand that too.